The truth of the matter is that it's actually a key plank in enabling people to access justice by giving people litigation funding. Access
to justice, I love that. If you're funding it, you can't actually be the lawyer as well. Is that right?
That's a big ethical no-no.
And you have an engagement of a lit funder, straight away, the other side's looking, holy moly, these guys are serious.
Yeah, it's the actual psychological effect that it has on the defendant as well. Like, this is going all the way. Reacting in anger or annoyance does not advance one's ability to persuade.
After this, I'm going to ask you to email that to me. All right, welcome to the MG Academy. Today we're lucky enough to be here with Aaron from Pragma. Welcome, Aaron.
Thanks, Marcus.
Oh, mate, I feel pretty special. You've flown all the way over from WA, mate.
Yeah, flown all the way over.
This morning, red eye?
On the red eye.
Yeah, right. What time's that land?
6 a.m. Sydney time. Yeah.
Mate, you're fresh.
Yeah.
Good stuff. Look, mate, thank you for reaching out. I understand you saw one of our podcasts, and at least someone's watching them. And mate, you obviously reached out to talk of all things kind of insolvency law and lit funding, and probably start off more so about you and your practice and what you do and how you found yourself in insolvency and litigation funding.
Yeah, I think it was Matt, who's from your firm over in Perth, who sort of put me up to go on the podcast.
Mate, no shit outs to Matt. Come on, mate. Love you, Matt.
But about me, I'm my day job's as a lawyer. I run a law firm called Pragma, which has got 57 staff, 32 lawyers, and a big part of what we do is insolvency and restructuring. Mm-hmm. And I set up the firm myself 11 years ago. It was just me.
Right,
I was a bit like Dennis Tenuto out of the castle. And then...
God, that's a great movie.
Then it's grown to something a lot more sophisticated since then.
Yeah.
And we're really about doing things quickly, cost-effectively. We're trying to sort of be not the traditional law firm at all, by being really solutions focused, particularly in dispute resolution.
Yeah.
So that's really what our reputation is.
Yeah, sure.
And then also as a side hustle, I'm a director of a company called Heartwell Funds, which is a litigation funder based in Perth, but doing funding all over Australia.
All over, yep.
And we've spent a lot of money setting up the business with an AFSL and a pretty... heavy-hitting board, which is sort of our investment committee as well.
Yeah.
And, that's been really good as well. It's an industry I've always been fascinated about, and I think I obviously can't blend the two, so you can't wear the lawyer hat, you can't wear the litigation funding hat in the same gig. So different opportunities come across my desk, and sometimes they're for me as a lawyer, but other times they're there as potential funding opportunities.
So sorry, when you say obviously if you're funding it, you can't actually be the lawyer as well, is that right?
That's a big ethical no-no.
Yeah, okay. Yeah, that's good to know, right?
There was a lawyer that attempted that, and it didn't end well for him.
I couldn't imagine it would, but I mean, that's a good point to note. And so it's not just that people are like, well, why would I refer stuff over to yourself? Yeah. Because I'm going to...
Well, the truth is, Marcus, all my competitors wearing my lawyer hat are now my friends, in funding, because I can't be the lawyer or the funding. And it's actually... I actually forget that people don't know that I can't be both.
Yeah.
And the truth is, when people realise that, they look at me involved and having an interest in a litigation funder, and they think, he's just doing that to sort of, prop up and find work for his own business. Not the truth at all.
Yeah. And so I just wanted to get that point across.
Yeah.
Because, I knew the answer to that, but others may not, and they go, well, what's all this about, right? And it's about providing a solution, as you say, right? When people are stuck in certain situations and there's a good matter or case on hand, you'll be able to help out. Righto, litigation funding, probably where I want to start.
Okay.
Look, everyone's after a good litigation funder. I'm getting calls and emails from accountants, from lawyers, from whoever saying, hey, do you know a lit funder? Sometimes they've got, I wouldn't say a reputation where they just simply kind of take the money and run because they get all the wins, because that's all you hear about, right? Litigation funder has got involved, paid one invoice and settled for $1 million, and they took 50% of it.
Yeah.
Right. What do they do? There's much more to that, right?
Yeah.
I feel that as soon as you have an engagement of a lit funder, straight away, the other side's looking, holy moly, these guys are serious.
That's a great point. It's the actual psychological effect that it has on the defendant as well. Like, this is going all the way. But sometimes defendants think to themselves, they'll run out of cash, they'll disappear, they'll will wear them down. But in most jurisdictions, particularly in Western Australia, if you're litigation funded, you actually are obliged to disclose that fact to the other side. There's in the rules of the court, you're required to disclose that, and as a result of that, the funders get to come to mediations and actually attend there.
I've seen it myself, particularly in the insolvency sense. And again, I'm not a liquidator.
Yeah.
I obviously help and manage files. I've seen it before where they're like, mate, jog on.
Yeah.
We've had a look at your statement of affairs. You've got no money, right? We don't care if we think we owe you or not. We're not paying you. What are you going to do? Lit funder comes in, literally, they've paid one invoice. It's a disbursement. It gives you, I guess, a stronger arm. It's a psychological effect, as you said, and it's that leverage that sometimes you might be looking for just to get over the line. Yeah. Now, tell me this: people come to me and they're like, "Mate, I've been battling with a debtor or someone who's breached a contract, damages claim, what have you, right?" And they're like, "We're at our wits' ends. We can't do anything else. We're about to appoint. We want to appoint you as liquidator or a voluntary administrator or something along those lines because we just cannot keep going." And they're like, "But, we want you to do it. We want you to go." And I said, "Well, look, mate, we're only as good as we are funded. Yep. So, if you just expect us to appoint us and then believe that we have an obligation to use our own funds out of our own pocket to chase something that may or may not get there, it ain't happening."
Dreaming.
So they're like, "All right, well, what other options do we have? If we're not going to appoint you, right, and you're not going to do this for us, yes, you're going to take the pressure off our shoulders, so to speak. We're dealing with some of our other suppliers, tax office and whatnot. But they're like, is there someone else that can look at this?" So I guess where I'm getting to is that for all those kind of accountants, insolvency practitioners and others here listening in, do you suggest perhaps that maybe you have a look at, if that scenario comes in, that it goes to a lit funder first?
Oh, absolutely. I mean, it doesn't cost you anything. We'll do the due diligence.
So the DD is free?
We'll run the ruler over everything for free. I mean, and we can work it out pretty quick. But if it's something worth funding, I mean, the criteria we're looking for is obviously a defendant with deep pockets or an insurance policy. I mean, you don't want to run a case and win and have the strongest case ever, but a party that can't satisfy a judgment. That's probably the first thing.
The commercial outcome,
that's really important. And you got to remember, on the commercial outcome, statistically, Marcus, 97% of cases resolved by consensus. It's only the 3% of cases that go to trial. I always remind clients of that because they actually forget. They always think they're going to have their day in court. Well, the statistics say otherwise.
So that's an interesting point.
So that's it. At Heartwell, we use the phrase low-hanging fruit. We're looking for low-hanging fruit. So something that should settle is straightforward. It's A, there's a defendant with deep pockets. B, it's meritorious on the legal merits. Like you actually think you're going to win. C, how much needs to be spent on experts and the like, and how quickly can we get it to mediation and try and resolve it? Those are really the main things in our mind when we're sort of reviewing a case.
Yeah. Well, I get on that point, and I guess which is I was trying to get to, is that it costs nothing to assess it.
Nothing.
Mate, it's a day, it's whatever. Just give us some files, let us have a look at it. And for me, mate, like I'm a little different to most insolvency professionals, I guess. If they can avoid my services, I'm also happy, right?
Yeah.
And I'm a big believer in karma too, right? So if there's an option there and it's going to be the best interest for that particular client, and all it's going to take is have a chat with your good self to get an indication as to level of appetite.
Yeah.
It's a no-brainer. And what I'm seeing in terms of types of cases is the old, what do they call it? The Goliath versus David and Goliath. Where you've got a top tier, particularly in construction, right?
Yeah.
You've got a top tier construction company or someone that's contracted to the government, and then you've got little old Peter down the road that is, subby, that's struggling, but they're just not paying his bills. Not really giving him a reason why, but whether they don't want to or whether they have an option. And they obviously, they bleed them out, so to speak.
Yeah.
I feel that is a great case.
Yeah.
And I feel in some instances people are taking advantage of their ignorance, so to speak. Inexperience. And it might be like, mate, you can do this, that, and the other, and it might be a solution for you. You might not even need to do a litigation funding, right? Yeah. You could send a couple of letters off.
Yeah.
I mean, this is the type of audience we've got here. We a lot of people that listen in are professionals, but they're also mum and dad business owners who are just looking for some different types of options, right? So
it's a good point. I mean, lawyers and judges often use the phrase access to justice, enabling people to have access to justice. One of the sort of views of litigation funders is that they're money hungry people, where they sort of they invest money, they pay one invoice and they take $1 million or they take the settlement. The truth of the matter is that it's actually a key plank in enabling people to access justice by giving people litigation funding. Former High Court Chief Justice Robert French, who's from Western Australia, did a review for the Productivity Commission about how access to justice can be improved in Australia. And one of his recommendations was, we've got to ramp up litigation funding. We've got to make it more accessible for people, because it's actually the person that would not otherwise pursue a claim, the subbie against the big principal contractor, with litigation funding, they might pursue a claim that they otherwise wouldn't. And that's enabling them to access justice.
Absolutely. Access to justice. I love that.
Yeah.
It's the first time I've heard it. Yeah, right. Okay. Yeah, so can you just step me through, I guess, the process in very kind of basic, high-level terms as to what needs to happen for someone to assess or to run through your assessment criteria?
I mean, in a perfect world, like we see a lot of stuff come across our desk, and the truth is we say we're quite conservative, because it's you got to remember it's basically an investment, like you're buying shares on the stock market.
It is, yeah.
So, but it's such a high risk investment. I mean, a lawyer once told me about litigation, there's only two certainties in litigation: uncertainty and expense. And it's true. And I tell clients that all the time. You can have the biggest slam dunk of a winning case.
Yeah.
Can all turn to a complete 180 on you without you even seeing it.
Yeah.
So you got to bear that in mind. So when we get lawyers, insolvency practitioners, or just claimants, punters themselves coming to us saying, can you have a look at this case? And so in a perfect world, lawyers come and go, here's the barrister's opinion on merits, here's the insurance policy for the defendant, or here's the properties that they own, so they're deep pocketed. This is our budget for what we want to get paid in order to run it through to trial. I mean, in the most sophisticated sense, they've really done all the work for us, and we just read it and tick it off.
So it's like a brief, right?
Yeah. And we read all that. Other times it's, somebody telling you in rough terms what the facts of the cases are, and you've got to sort of do your own homework to sort of work out for yourself.
Yeah, and I feel there's a lot of, a lot of my client base here is in Western Sydney, right? A lot of them are unsophisticated in the kind of business sense, legal sense, what have you. And like whenever I'm approached, it's usually like, here it is, kind of sorted out.
Yeah.
And, I feel like a lot of the people in the fast-paced city life are like, don't worry, I'm not interested in that. But there is some diamonds in the rough there.
Yeah.
And for myself in particular, I find that when I have the time and I look through it, mate, it not only is it good for business, but it's good for that client as well. And someone's listening. So it comes back to access to justice, right? Like give some time and
you got to put, it's like anything, you got to put the work in, to find to have a return. You can't just expect money to.
Everyone says, like, how do you build your client base? I'm like, mate, have you heard of door knocking? Yeah. I go out and knock on doors, man. I do, as I said, I think 5 to 10 a week. New people I don't know. I just go knock on the door.
Wow.
How you going? Some of them tell me to jog on. Some of them don't. I have had instances where people have asked for lit funders.
Yeah, right.
Yep. They're mainly lawyers.
Yeah.
Suburban lawyers and whatnot, but still, okay, cool. All right, so there's really no kind of hard and fast rule in terms of putting forward a litigation funding process. It's, you've got a query, you've got your details, and then really kind of it's a bespoke type of situation where you'll just ask for certain info, give them a high level.
Yeah.
What about retaining some of if they've already got a lawyer on it?
Yep.
Do you prefer to have your own lawyers? Obviously, you can't use yourself. Naughty.
Can't use myself. Obviously, you don't want to bite the hand that feeds you, Marcus. So if it's come to you via another law firm, you're never going to try and turf them out. But I always like to sort of, like, for example, I've just funded one yesterday up to mediation. Looked at the team. It came to me from a law firm who's a friend. Law firm's completely fine. But I thought to myself, why don't we throw like a senior counsel barrister on this as well to do the advocacy and the mediation and really show them what
we mean business.
We mean business. Because they had a barrister already involved, was it would not have been my first choice. Nothing against him. I just thought, and I was thinking also about the lawyer on the other side who I know, who he'd resonate well with, who he gets along with. So
that goes into it too, right?
Yeah, those sorts of things cross my mind. You
don't even think about that, but so, absolutely. And also too, like as you say, like they've had a barrister on it who would certainly not be your first choice, and that's not because it's a bad choice.
Yeah,
it's because maybe someone doesn't, or someone knows someone else that kind of could do it better, or doesn't necessarily have the experience that you might have in that area. It's like, I know the man who can do this, or the lady, or whoever it is, right? They've done this before.
Yeah.
And then it comes down to, okay, well, we're trying to preserve a relationship here, or we're trying to get a result for the client.
Yeah.
And I think that's really important as well for people to understand. Okay, cool.
The other benefit of using a litigation funder is that it's not just that you get somebody to pay the lawyer's bills, but you also have like a strategic partner who is a professional at instructing lawyers on what to do. Because at the moment I'm doing one. We put $600,000 in a bank account to run this case, and not only are we just paying the lawyers' invoices the day they're issued, but we're also on every email in being involved in every strategic decision in circumstances where the claimant, who's unsophisticated, wouldn't know which way to steer it.
Well, it's almost like you're releasing a pressure valve for him too.
Yeah.
It's like, this is what you do. You're invested. You got skin in the game now.
Yeah.
I don't really have to worry so much because I know I've got someone who's got aligned interests to get the result.
The other big benefit of litigation funding is security for costs.
Yeah.
So, because particularly insolvency practitioners who are personally liable for everything, they don't want to go and commence a big insolvent trading claim, lose, and then not only lose, but then get hit with a $500,000.
That's a big one, mate.
So we'll put up an indemnity for the legal. So it is a free hit.
It's cover. It's like insurance.
Yeah, it is like an insurance. So we cover that.
And How many of your insolvency ones do you do that go to trial?
Haven't had one yet.
Yeah, okay. That's interesting.
One yet. Not one that I funded.
Yeah.
Yeah, the business is still in its infancy. The chair of our board is a guy named John Poynton, who's a very prominent business person in Perth and across Australia. Sits on the Poynton is on the chair of Australia's Future Fund. He was the chair of Crown. He's
right. Okay.
Yeah, he's a
big deal.
Yeah, he's a big deal over in Perth.
Yeah. Okay. And so, is there anything is there an industry or an area that you won't touch?
No, not really. Construction can be difficult with some of the claims because you need a million experts to sort of establish what went wrong, and that can be tough. But no, we'll take a look at anything. We'll take a look at anything.
So is there any kind of red flags in an application? Like when someone puts something through and like to even just save them wasting their time and your time, is there something that's just absolutely not? For example, someone comes to me and wants to appoint a liquidator when there's a wind-up on fault. I'm like, mate, save your time.
Yeah. That's a good question. I think the punter with $150,000 equity in their home's probably a waste of time, that sort of stuff. And that's something you can work out pretty quick.
Yeah, you'd hope that the professional referring them on won't necessarily do it. But again, for a lot of those people out there who don't necessarily have representation or overly, they have a claim but they don't really know what to do about it, they might kind of reach out in those instances. So there we go. So your insolvency practice over in Perth.
Yep.
Tell us a bit about, I know you've high level, but what's your sweet spot? What do you look for? All things insolvency.
Yeah, all things insolvency. We do work like most other law firms that practice in that space in Western Australia, and I imagine just like Sydney. We do work for Mackay Goodwin, but we do work for lots of different insolvency practitioners across Perth. And so yesterday I was in court this is probably less than 12 hours ago. I was appearing before a judge to vary a DOCA on urgent circumstances. We got the instructions at midday and we got the hearing at 5 p.m.
Yeah.
So that was pretty frantic. But we do, acting for proponents and insolvency practitioners in relation to restructuring and putting up DOCA proposals and getting them passed, attending creditors' meetings, extending convening periods, applying to courts for receivers to be appointed, anything and everything really. I'm sorry, and we also do all the preferences, all of that.
Sure. So I mean, a lot of the people, my when I say followers, not like, I don't have disciples, but a lot of my contacts, so to speak, are, East Coast based, and I often get calls from pre-insolvency advisors, from other liquidators, even lawyers, right, to say, do you know someone in Perth who can, mate, we've got one of our clients just received a wind-up notice. We're looking to refinance out. It's coming. It's not far off.
Buy some time.
We just need someone to go there and represent us and put forward our defence or our argument to try and buy some time to make this happen.
Yeah.
And that's something that you'd certainly do.
We've done that many times. I mean, we did that the other day for a company who had a big ATO debt, but was in the process of amending all of his tax returns to reduce all of that down. And of course, the statutory demand had been and gone, and then the winding up application had commenced, and we get the call. So he's come to us too late to begin with. I mean, he should have come to us much earlier.
Yeah, but some of them don't know.
Yeah.
They sit there and they're like, what is this? Like, I've already been able to rack up this debt with the taxman for how many years? Here's another piece of correspondence. Don't worry about it, because nothing's going to happen. Well, no, actually, mate, you're at your last end. You're at your wit's end.
Yeah.
This means the end.
Yeah. A lot of people don't understand that. But in that circumstance, rather than rolling down to court and saying, oh, Your Honour or Registrar, we'd like another 4 weeks or 6 weeks, I often get them to put on affidavit what they're doing to take steps to have the proceeding dismissed or to repay the debt, and then hand that up to the court. And that has so much more probative value to persuade the court to actually give me the extra time.
Yeah, well, there's reason, right?
Yeah. I mean, because any lawyer can walk in and go, oh, Your Honour, I'm instructed that.
Yeah. What's that section? Section 4 something or other, 473 or... mate, I'm not a lawyer, obviously. But there's one was like, I think just use the court's discretion to extend it. I'm like, no, mate, these days have changed, right? You need to have some solid evidence and reasons, or at least something to put forward, because you haven't acted thus far. What's to say you're not going to do it again, right?
And it becomes more acute as the longer it gets. Like the first return hearing, you probably would have get one just by asking for one. Oh, Your Honour, I've just been appointed. We're looking at it. Can I buy 4 weeks? No worries.
Yeah.
You come back the next time in 4 weeks' time and you haven't done anything.
No.
Like you're going to be in trouble.
Yeah, absolutely. Well, I had one of the tax office representative from the SBR team come over recently, or come on the podcast, and he said as well, look, all that's taken into account. Like obviously everything's on a case-by-case basis, particularly for SBR proposals and whatnot. But he's like, we obviously need to consider the time and cost and effort that we've put in to get to this point. So clearly, it's not that they're going to have more sting in it. They're just not going to be as, I guess, easy to convince to either extend or accept a proposal. So the earlier you get it in, the better, right? Because they want people to interact.
Yeah.
They want interaction, and they want people to work with them.
Yeah.
So
another one I see a lot of is the winding up application on foot, and then they go, oh, we want to tip it into VA, and there's a legal proceeding on foot to wind the company up, and it's always a sort of a toss of a coin as to whether or not you can stave off the winding up in order to get the VA up in that period. And the cases on that say, well, you need to show the court that it's in the creditor's interest for the VA to continue. And that's always tough with the VA's been appointed 3 days before the hearing.
Oh, look, I mean, the amount of times that people have come to me saying, hey, would MG consent? When's the hearing date? 2 or 3 days. I'm like, mate, you're kidding.
Yeah.
Like even if you had a DOCA proposal, it'd be hard to fight.
Yeah.
And it's becoming more and more often where it's actually the administrator that's copping the heat for taking on the appointment, right?
Yeah. Ostensibly, they've got a lien, but they never get paid out of that, really.
No, then the judge rips them apart.
Yeah.
Why'd you do this? Well, if there's a genuine claim proposal there, and they do want to put it forward. And my thing is, if it's in the best interest of creditors, well, there shouldn't really be a time limit on it.
Yeah.
But it's the perception, right? So, okay. So, moving on to kind of tax debt and distress and whatever, here in New South Wales, the heat is on, right?
Yeah,
the taxman is wants his money, and fair enough.
Yep.
Enough's enough. Is it everyone's saying, oh, each state is different. Oh, Melbourne's similar to New South Wales, but you know what? Victoria's similar to New South Wales, but Queensland's a little cooler. What's it like in WA at the moment,
I reckon
mate?
They say that WA is a bit more. I reckon it's a little bit more rosy. I'm just taking a stab in the dark here. I'm obviously not.
Yeah, I mean, this is all stab in the dark. Your feet on the ground over there, so you'd see it, right?
I reckon it's a lot more rosy. It's a real boom and bust town, Perth.
It is
because
the mining, right?
The thing is, the whole town, the whole state revolves around mining.
Yeah.
Like if you're not in mining, you're probably it's somehow tangentially connected to mining. You're a mining services contractor. You're a lawyer doing stuff for mining. So you see these guys with incredible wealth, but also guys that run these mining businesses into the ground as well. So it's sort of like both ends of the spectrum. I mean, I'm sure we've got lots of punters with significantly outstanding tax debt.
Yeah.
But yeah, I imagine it's not as severe as it is over here. I mean, like everybody else, I get that 6 a.m. email, insolvency notices.
Love that.
I mean, proportionately, you guys over the last 12, 24 months are absolutely killing it. You speak to the guys in Perth who are insolvency practitioners who have a national firm. They go, I'm a bit quiet, but geez, the guys in Sydney, and luckily for them, they can jump on the files in Sydney and do some work there.
Well, that's exactly right. Yeah. Absolutely. Yeah, and that's the beauty of having kind of that national practice as well.
Yeah.
Now, this is an industry that I see a lot of at the moment, is mining and equipment, right? It's got to go from mine to mine to mine. How does it get there? What happens? It's transport, right? Transport companies are doing it tough, right? And there are a lot of big transport companies over in, or trucking companies in WA. And more importantly, my favourite show, Outback Truckers, which is based, I think most of them are in WA, keeps me entertained. But I see the people now, they're just like, the distances are long, the diesel or whatever it is increasing. The taxman's not willing to, give us some form of, breathing space. Yeah, we can't get drivers. And then I reckon a couple of weeks ago I had one who's like, mate, I just kept going, and then I just got my insurance bill in, and he said last year he had a fleet of 10, 15 trucks. He said last year was 50 grand. He goes, overnight it's gone to 150,000 bucks. Like, I'm just going backwards. Like, it makes no sense. I dare say that's a similar type of feeling that the others within that game over there are feeling. Yeah. But then what happens to the mining side of things? Like, mining is, as you say, is propped up by all these smaller services.
Yeah.
So is it a case where it's like a domino effect where the mining can't get some of their equipment and plant equipment up, or?
Yeah, I don't probably see the domino effect so much, but I'm sure it's there. I'm acting for a truckie at the moment in a federal court case, and just to pay the legal fees on it, is just like, it's doing his head in, and he's really, you're going to see it's affecting his mental health and all of this stuff.
Yeah.
As a small business, it's a tough game to be in, I think.
Oh, honestly, like we see them all the time, and then, but that thing's worth, I paid 150 grand for that truck last year. You flood the market. You go out there, you're not getting anything.
Once it's aged, particularly, I was at a presentation yesterday where I think it was Gordon Brothers did a presentation about the market for resale, and they were saying that once the equipment gets to a particular age, it's almost unsellable. Like, the price goes through the ground. So
So do you over in WA, and forgive my ignorance, and you guys are all the way over there, man. And I love WA, I love Perth. I really want to go fishing over there.
Oh, yeah.
I've had some interesting decisions come out of WA.
Funny you should say that. I mean,
really interesting.
The tone of the correspondence that I get from the Sydney law firms, in my view, is just so unnecessarily aggressive. So unnecessarily aggressive.
It's almost personal.
Yeah, and with Perth, I look at these letters, I look at them, and I walk around my office, I show them to other lawyers, I go, no lawyer in Perth would write this letter.
Mate.
No lawyer in Perth. And because we're sort of, I think the reason is, this is my hypothesis, it could be completely wrong, is we're like a country town, you know. The guy you're writing a letter to, like you're going to see him, you know, at the next function or down the street. You don't go and...
You know what? It's a shame that we've sort of lost that touch. Like,
and I think because Sydney is a proper international city, you know, you could literally write a letter to somebody else in town and probably never meet this person, you know, never ever see them. But a little tactic, and this has taken me years to learn, but like writing an angry letter, the famous US Supreme Court judge, she's passed away now, Ruth Bader Ginsburg, the notorious RBG, they called her. She had a line where she said, reacting in anger or annoyance does not advance one's ability to persuade. So when you're writing a letter to somebody else...
After this, I'm going to ask you to email that to me.
It's a great line.
Yeah, mate, absolutely. I'm like that sometimes.
Yeah.
Like knee-jerk and wish I didn't do it. And so many others. I'm like...
Got to give it the 24-hour...
Have you ever actually written that back to someone when you've got one of these filthy letters?
I've used it many times, but I always think that. And what I've noticed is the guys that email you the really aggressive letter... and get quite personal, and they want you to respond. They want you to go have a get into the fight or flight.
Because they're
fight or flight. And when you actually sleep on it, give it a day, and you write the letter back, and you kill them with kindness, it actually annoys them more.
Mate, it's so true.
So you just always got to be the biggest
person. I was just thinking about this. There's another liquidator. Come say g'day. You're on a podcast, but that's all right. Just reverting back to your lit funding side, what is the minimum amount that you'll look at in terms of...
Most lit funders use a ratio of 10 to 1. So, like, the funding element needs to be a tenth of the claim amount. So,
right.
So if you're going to, generally speaking, if you're going to be pursuing $1 million claim, you're going to need to put up $100,000. And that's what they look for. You don't always get that. That's probably in a perfect...
So that's the rule of thumb.
That's in a perfect world.
Can I ask a question? Not selfishly, but in our scenario, if we're going for an insolvent trading claim, is that how we should... I mean, I know there's no hard and fast rule, and it's not advice.
Yeah.
But everyone's like, why aren't you going for that guy? Insolvent trading, took on debts, you need to do it. And I go, yeah, but he's got $150,000 equity in his house. That's all he's pretty much got, or she's got. And, you know, it's going to cost... They've already said they're going to vigorously defend any claims we make. How's that going to benefit creditors?
Yeah.
You know what I mean? You're going to soak it all up in legal fees. Probably all right for you, mate. But
well, there's no point doing that. You're right. It's not going to be in creditors' interest at all.
So 10% is a good guy.
Shooting a shot across the bow saying we're going to commence proceedings. Do you want to come and meet and try and cut a deal with him where you can just try and get something? That's worth doing.
Yeah.
But commencing legal proceedings when he's got $150,000 equity and might go bankrupt, unless he's got something hidden there, or there's a D&O policy, which is rare these days, unless it's a big entity.
Okay, and moving on to like accountants, I often get calls from accountants saying, "Hey, I've got this situation." I'm not a bloody lawyer. I can give you my opinion and my experience and what I think it is, but are you and your staff, you're free to just, hey, anyone's got a bit of a legal question here, just want to pick a brain?
Yeah,
because I do that. Like, I workshop. That's what I say to everyone. Mate, you tell me. I got an accountant who goes, mate, this is going, they want to send this job to that liquidator, right? No problem. But can I still use you to bounce ideas off and get your opinion? Anytime.
Yeah.
Anytime. Is it a similar type of case with yourself?
100%. 100%. I mean, I'll have meetings in my office all the time, which I don't charge for.
Yeah, mate, so do I.
I mean, like, you just got to do that. I mean, you can't be out there trying to charge for every minute of your day, you know. And it comes in swings and roundabouts. You'll lose on some, you'll win big on others, you know.
Yeah. So that's probably something you'll get from this as well. Is just that I'll just say, go speak to Aaron. You know, have a chat, bounce some ideas off him.
Yeah.
And guess what? He's 4 hours or 2 hours or whatever he's behind. So this call at 8 p.m. You might be just getting in, mate. You know what I mean?
Yeah.
He might be leaving for his first beer. Okay, yeah. And so, look, just finally, just with the applications themselves, like when I say application or approaching you for lit funding, is there anything that you would want someone to bring to an immediate attention? Is there something that they should highlight to get your attention rather than like having to get them to for you to dig around and find it? Is there something that's the smoking gun?
We actually have a form, actually. I don't know if it's on our website, but we do send it to people occasionally going, we'd like this information. It's pretty basic stuff. Like, is there an existing legal proceeding on foot? If so, can I have the writ, the pleadings, the key documents? I don't want you to send me 78 court documents, but I want the key 4 or 5 ones. The parties' names. What proof have you got that the defendant has pockets to satisfy a claim? Have you had a mediation yet? How did that go? Are you having another one coming up? Those are the sorts of things I sort of ask and look for at the very beginning.
Okay.
Yeah, any sort of key correspondence going back and forth. Usually they come to me and they've already got a lawyer involved and they've already started to exchange correspondence. The other thing about lit funding is, and one of the reasons we set up Heartwell is, like, there's so many lit funders who have, like, the classic one is one based out of Western Australia, actually. It's been so incredibly successful. It's called Omni Bridgeway now. It used to be called IMF, and it's listed on the stock exchange. To get through the front door of that business, your claim has to be minimum $20 million.
Shivers, sorry.
Yeah, and so the truth is, we're not in that market.
No.
We're in the market underneath it. There's so much
volume in that.
So much good stuff in there that people just don't pursue. And
so what about if there's, like, let's just say that the company goes in liquidation, they've got a couple of contested creditors or debtors or something along those lines. Should we just reach out and see, even if it can't be lit funded, maybe a letter?
Yeah. Absolutely.
So anything that comes over, it's got a taste to it.
Nothing to lose by having a throw at the stumps with that.
No, absolutely.
And I'd happily look at that stuff for you, Marcus, anytime.
Yeah, any last questions?
It's been great to meet you, Marcus.
Yeah. No, likewise. And I really appreciate you reaching out. It's the first professional. Because I'm like, yeah, tell me who watches this? And some people do, mate. Like, you got to be real. Like, don't get me wrong, there's a lot of us professionals who are educated and experienced and we know what they're doing. But there's a crap load more that are not. Yeah. And, when someone has a genuine question, so to speak, in terms of, see you later, in terms of, can I do this? Well, they often get responses like, well, section 7377 of the bloody act. And the guy's like, well, is this guy speaking English?
Yeah.
And so they're not getting they're not able to be communicated or understand for them in their mind to make to make an educated decision,
Yeah.
And so I try and just bring it down to earth and just let people know.
Yeah.
That's the whole point.
Yeah.
Mate, Aaron, I really appreciate your time.
Pleasure.
I love your socks as well, mate. We'll wear similar ones next time. And yeah, mate, it's
pleasure's mine.
Enjoy your wedding. All right, guys. So I'm just going to wrap this up now. Thank you, Aaron, for coming in to meet with us and have a chat, all things insolvency law, and lit funding and safe travels on the way home. And for those lawyers, accountants, and I guess brokers as well, looking for CPD points, look in the comments below for ways to get your certificate. Thank you.
Thanks,
Cheers,
Marcus.
mate.
Cheers.
Cool.